Welcome to Employment Law This Week. I'm George Whipple. Our top story, the Zika virus on the march. For the fourth time in history, the World Health Organization has declared a global public health emergency following the spread of the Zika virus throughout Latin America and the Caribbean. The disease can have harmful effects on fetuses, and the CDC has warned against travel for pregnant women and their partners. The Zika crisis has important implications for employers. Workers who travel for their jobs may request accommodations, and employers should make them aware of the risks if they aren't already. Here's Denise Dadika with more advice for employers.
Keep monitoring the CDC's website to get additional information, specifically as it concerns any travel restrictions or travel bans that may be put in place. So that will allow employers to make informed business decisions about whether their employees should be traveling or working in those countries. Managers are going to be the first line of communication with the employees who are expressing concerns about the Zika virus. So they need to have an understanding of, how they should respond from an HR standpoint, but also about the legal implications that could arise. So at a minimum, managers should be instructed to reach out to human resources when they're confronted with any concerns from employees about the Zika virus. And if managers are keeping human resources abreast of the situations that are occurring, the employer can ensure that it's taking a consistent approach to the issues that are being raised by employees in the workplace.
The U.S. and the EU agree on a safe harbor replacement framework. Negotiators from the European Commission, the executive body of the European Union, and the United States have agreed to a data transfer pact that will allow for the legal transfer of personal information across the Atlantic. The new Privacy Shield will require, quote, strong oversight by the U.S. Department of Commerce and the FTC to ensure protection of personal data from individuals in the European Union. U.S. companies receiving personal data from the EU will now likely have stronger obligations to protect the individual rights of EU citizens under the agreement. The new data pact will require political approval. In the meantime, the EU's standard contractual clauses and binding corporate rules remain valid. The Third Circuit defines contributing factor under the Sarbanes-Oxley Act. A former employee brought a retaliation claim against electronics maker Tyco, alleging he was fired after whistleblowing activities. Tyco argued that the whistleblowing was irrelevant to his firing, which they claim was based on a well-documented investigation into sexual misconduct. The court ruled in favor of Tyco, and in doing so, established a new standard in the circuit for a contributing factor, defining it as any factor which alone or in combination with other factors tends to affect in any way the outcome of the decision. Employers prepare for the H-1B lottery. In less than 2 months, employers will submit their H-1B petitions to the USCIS, hoping to get one of 85,000 employment-based visas available for fiscal year 2017. The number of H-1B applications has increased in each of the last 3 years, with 233,000 applications filed for fiscal year 2016. Employers making decisions on who to support for these visas should keep in mind that F1 students with STEM degrees face special challenges in obtaining extensions to their optional practical training due to a recent district court decision. And that brings us to our tip of the week. Here's Mary Rose Manis from Warner Music Group with advice on cybersecurity for global companies in light of the new Privacy Shield agreement.
As companies expand globally, there are a lot of things they need to consider. One of them, which is key, is cybersecurity, something that's really not easy to navigate, even amongst the most sophisticated companies. Privacy laws are also something that are rapidly growing and a concern for many companies, even companies with a huge global established presence. In February of this year, the European Commission and the Department of Commerce finally came to a tentative agreement on what's called the Privacy Shield. And what that basically is it's replacing Safe Harbor, although it's a little bit like Safe Harbor, but it's going to be much more restrictive for employers and provide much more obligation on the employer moving forward. So what does that mean for companies and for you? It's really important to get the advice from the experts in order to stay compliant and stay ahead of the game. And most importantly, really get to know your outside regulators so that you can remain in compliance and stay ahead of the upcoming laws.
Thanks, Mary Rose. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.